Okay, we're going to go ahead and get started just to make sure that we can get through all of the content that we have planned today. This is Amanda with HRX Services. So let's go ahead and begin. Good afternoon, and thank you for joining us today for our HR legal update. We can appreciate the amount of information that's being shared out there, and we know you have choices of where to spend your time. So thank you for sharing some of your time with us today. I know this will be an informative hour for all of us, and I'm looking forward to getting started. Now, before we begin, I do want to address a few housekeeping items and things we want to note. First, this session is being recorded today. If you do not want to participate in a recorded session, please exit the webinar at this time. In the same vein, today's date is April 28th, 2020, just in case you happen to be listening to the recorded session at a later date. Some of the information may be updated or have changed since this has been recorded. I would also like to take a quick moment and share that the team from HRX Services are not accountants, tax professionals, or attorneys. And while Colin is an attorney, he will be sharing information from a general perspective, and nothing being presented today should be construed as legal or financial advice. Anyone needing legal or financial advice specific to their own organizations are always encouraged to consult with their partners in those areas directly. Our hope is also to be able to work through the session today and provide some time for Q&A at the end. And for that reason, I would like to direct you to the tools box in your webinar screen at this time. You can find the questions and answers box. Now, there's also a chat feature, and so if you need anything from us as moderators, you can certainly use that tool. But for questions, we would direct you to the Q&A specifically, because we're able to pull a report from that tool in case we aren't able to get to all of your questions today. We can circle back with you at a later time. Once again, I'm Amanda Erickson with HRX Services, and I'm joined by Jeannie Valier with HRX Services. Jeannie, would you like to take a moment and say hello?
Hello, everyone, and I'm excited to be a part of this webinar and look forward to Colin.
Thank you, Jeannie. Jeannie and I will be moderating those Q&A areas as we work through the session today, and again, we hope to have time at the end for those questions. So let's get started. Today, we are excited to have Colin Walker, attorney and director from Fairfield & Woods law firm based here out of Denver. Now, we've known Colin for several years as he serves as the COSHRM, or Colorado Society of Human Resource Management, State Council Legislative Director. Colin brings more than 20 years of trial and litigation experience, including employment, commercial, and intellectual property litigation. He handles disputes involving trade secrets, non-compete agreements, termination issues, unemployment proceedings, discrimination, harassment, retaliation, wage claims, and other employment-related conflicts. Colin's recent experience includes representing a company in a trade secret dispute, defending a public hospital from alleged Family and Medical Leave Act violation claims, and defending a salesperson against allegations of a breach of a non-solicitation agreement. Colin works with employers ranging from startup companies to large organizations. His goal is to work toward proactive solutions to help clients prevent litigation and plan for potential problems in the workplace. Colin, welcome to our session today, and thank you for being with us. I'll let you take it from here.
Thank you, Amanda. It's wonderful to be here, and thanks for inviting me, and thanks to all of you who are listening in for joining me. These are exciting times, and even though they're not always fun, it's interesting, and it's my pleasure to try and help all of you stay up to speed on all these developments. Here's the agenda for today. The Families First Coronavirus Response Act, FFCRA, the COMPS order, and the new pay equity law in Colorado. I do want to mention that just in the last 24 hours, there's been a development. It's what's known as the Colorado HELPS rules have been amended as of yesterday. Those are the rules which provide for up to 2 weeks of paid leave at 2/3 of pay for coronavirus testing or coronavirus-related isolation or quarantine. I haven't had a chance to really digest that yet, but if you get on the Department of Labor's website, there's some good information, including some good questions and answers. And from what I did see, it appears that those are significant changes. So I suggest that you all get on there and take a look. As most of you may know, that those rules only apply to certain industries. One of the big changes that's been made is that the list of industries has been expanded very substantially. So if you weren't covered before, you may be now. So I urge you to get on the CDLE's website and take a look at that. But we're going to start off with the Families First Coronavirus Response Act. This was a statute enacted back in March and by Congress, by the federal Congress, and it had a number of provisions. But the main provisions that we're interested in as HR professionals and employment lawyers are the emergency paid sick leave and the expanded FMLA leave. So that's what I'm going to focus on. The FFCRA went into effect in April, so it's already in effect, and it ends December 31st, 2020, unless it's extended. And of course, none of us know how many of these laws or how the things we're going through are going to last. So we'll see if it ends then or not. But we're going to start off with the FFCRA. The Department of Labor has issued regulations just a couple weeks ago. They are by far the most detailed interpretation of the statute so far. I'm going to be referencing them as they relate to specific topics as we go on. I do want to mention that the state of New York filed a lawsuit challenging these regulations, and I'll touch on that again on a topic-by-topic basis. But regulations are commonly challenged, and there's a process that an agency has to go through. In this case, the regulations were issued on an expedited basis pursuant to some authority that was in the FFCRA itself. For obvious reasons. This is an urgent situation. And it's common for states and private parties to challenge regulations. It usually takes more time. So, but again, this is unusual. So I'm not sure where this lawsuit is going to go or how quickly it's going to go there. But I do want to mention that there is at least one challenge to these regulations. So they may or may not be in effect in their current form. Now, I will say that the lawsuit did not challenge each and every provision of the regulations. It challenged a handful of them. So I'm not saying you shouldn't follow them, but I am saying you should pay attention, and we'll talk about that more as we go along. The other thing I wanted to mention is that the Department of Labor also has some questions and answers which have been updated several times, and you can find this on the Department of Labor's website. I find them to be pretty useful. There's a lot of detailed information and a lot of examples and some of the trickier questions. So those are some things to be aware of. We're going to start with paid sick leave. This, along with the expanded FMLA leave, applies to employers with fewer than 500 employees. For full-time employees, the employer has to provide up to 80 hours of paid leave. For part-time employees, it's commensurate with the amount of hours worked over a 2-week period. This gets a little tricky, and this is one area where I would direct you to the questions and answers on the Department of Labor website, because this is one area where they provide some really useful examples. It gets even trickier when you start talking about variable schedules and variable rates of pay. That would include things like commissions. It would include things like, when a part-time employee doesn't work in a certain every day, certain days of the week, or every week, certain days of the week. And in that event, you're supposed to use a 6 months average. So again, that gets a little complicated. It's a little bit beyond what I'm talking about today, but there's some really good resources on the Department of Labor website that describe that. So paid sick leave applies when an employee cannot work or telework, and that's important. Teleworking is mentioned throughout the Act, the regulations, and the questions and answers. The employee cannot work or telework because the employee is subject to a quarantine order, a healthcare provider has advised the employee to quarantine, or the employee has symptoms and is seeking medical care. And I had that in that purple color because I like to, in my mind, I like to separate that from the rest because those first three apply to the employee, him or herself. The next three do not necessarily apply to the employee. So the fourth one is caring for an individual who has been quarantined, so some other individual. And the fifth one is caring for a child whose school or child care is closed. The last one, which I've highlighted in green there, is an odd one. Any other substantially similar condition. Well, what does that mean? Well, it's determined by the Department of Health and Human Services with consultation with the Department of Labor, but they haven't done that. So at the moment, as far as I know, that's kind of a non-factor, but it's there, and I don't know if it ever will become a factor. If it is, if they do issue some rules on that, my guess is there'll be a flurry of activity on the internet, but you may want to keep your eyes open. The two broad categories are an employee's own health condition, and then leave that's required because they're caring for someone else, including a child whose school or child care is closed. If any one of those criteria are met, they will be entitled to the paid sick leave. How much are they entitled to be compensated? If it's for their own health condition, the first three that I highlighted in purple there, they're compensated for at the regular rate of pay, subject, of course, to minimum wage. The statute says that, but that kind of goes without saying, I think. And if the leave is for one of those other reasons, a sick individual, a child, or a substantially similar condition, whatever that means, they must be compensated at 2/3 of their regular rate. There are limits to this, and here they are: not to exceed $511 per day, or $5,110 in aggregate. For those reasons, and then for the non-employee reasons, $200 a day, $2,000 in the aggregate. There is a limited refundable employment tax credit for these payments, and that gets fairly complicated. And again, there's some good information on the Department of Labor's website for that, but there is that tax credit that a lot of employers are going to want to be receiving. The employer may not require the employee to use other paid leave provided by the employer before the employee uses paid sick leave here. So this is going to be in addition to any leave that the employer has already provided. The second broad category under the FFCRA is expanded FMLA leave. And this is for employees who cannot work or telework. Once again, teleworking counts, because they need to care for a child whose school has been closed or whose child care provider is unavailable due to coronavirus. It applies to, once again, employers with fewer than 500 employees. Now, notice that the normal threshold for FMLA is 50 employees. So under the normal provisions, if you have less than 50 employees, it just doesn't apply to you. Here, that is an exception. Even if you only had a couple employees, this would apply. But only as it relates to the FFCRA. The employees are eligible if they've been employed for at least 30 days. Notice that's not the case with the emergency sick leave. Employees are immediately eligible for the emergency sick leave. And businesses with fewer than 50 employees may qualify for exemption if the requirements would jeopardize its viability. What does that mean? There's no good guidance on that. There is some guidance on the Department of Labor's website, particularly in the questions and answers, but it's not very helpful. They say it means kind of what it says. They do encourage you to document the reasons and to be prepared to present them. They tell you very clearly not to send them to the Department of Labor, so they don't want to wade through a bunch of documentation that shows that you think that you qualify for this. So one of these things that I think is going to have to come out in the wash. So this is obviously a little different than the emergency sick leave, but particularly with childcare, I think this teleworking language is important. I know a lot of us have employees, and we may be doing this ourselves, where we're teleworking because the employers asked us to comply with the stay-home orders and so forth. Our children are out of school and out of daycare. So you're going to have a lot of employees saying, I'm at home, I'm working from home, and I'm taking care of my kids. So they may think that they're entitled to this. If they are teleworking, then they're not, because teleworking under this provision is just like working itself. The expanded FMLA leave, for the first 10 days, it may be unpaid. Why is that? The reason for that is that for 10 days, the emergency sick leave applies. So these two provisions, emergency sick leave and expanded FMLA leave, complement each other. So the Congress didn't want you to have to pay for those first 10 days and the 10 days for emergency sick leave because, as we just discussed, caring for a child whose school has been closed or daycare has been closed is a reason that entitles the employee to emergency sick leave. It also entitles the employee to expanded FMLA leave for a longer period of time, but they didn't want the employee to be able to recover twice. So for the first 10 days, expanded FMLA leave may be unpaid. Thereafter, it's 2/3 of the pay for up to 10 weeks. Note again, this is consistent with the emergency sick leave. For the reason of child care, it's 2/3 of pay, unlike leave to care for yourself. The same cap as we discussed before, $200 per day and $10,000 in aggregate. Limited refundable employment tax credit for payments, similar to the sick leave. Reinstatement is required for expanded FMLA leave if you've got 25 or more employees. If you've got 25 or you've got fewer than 25 employees, you still have to reinstate, but there's an exception. You don't have to reinstate if the position no longer exists and the employer makes reasonable efforts to place the employee in equivalent position. The materials provided by the Department of Labor suggest that you carefully document that, and I would certainly suggest that as an attorney, because the Department of Labor may not be real interested in enforcing that now, but they may be at some point. So make sure you can establish, if you're going to take advantage of that, make sure you can establish that you had good grounds to do it. And this is a very interesting subject, intermittent leave. As those of you who have dealt with the FMLA know, intermittent leave is definitely allowed under the FMLA. It's been that way for years and years and years, and there are a lot of detailed rules. There's a lot of scholarly writing. There are a lot of court cases on that. And it can be very difficult. It's difficult to allow employees to take their FMLA leave in small blocks of time, keep track of that, make sure it's not abused, and make sure that their duties are being covered and all that kind of thing. It's a difficult thing. The act itself, the FFCRA, is totally silent on intermittent leave. Doesn't say one way or the other whether you can do it. The regulations came out and said that intermittent leave can only be used under some circumstances, and one is only if the employer agrees. That was a real eye-opener for me. That got my attention because that is absolutely not the case under the FMLA. And keep in mind that the second part leave that we're talking about here, the expanded FMLA leave, is still under the FMLA. So I really had a question as to, number one, where they got that, because it doesn't, the act doesn't say anything about it. And number two, why would that be when, the FMLA was required for years, and at least with expanded FMLA leave, it's required. Intermittent leave is required. But the Department of Labor and the regulations said that the employer has to agree in order for the employee to be able to take intermittent leave. The second thing is that intermittent leave cannot be taken if the employee is working on site except for childcare. Now, why would that be? Well, first of all, keep in mind that not everybody is teleworking or working remotely. There are critical industries out there where people are going to work just like they always did, or are going to work in some, a slightly different way, but they are working on site. So the commentary to the regulations and the information on the Department of Labor website says that the reason that they said you can't take intermittent leave if you're working on site is that they're concerned about spread of coronavirus. So if you have to, if you're on site and you're experiencing coronavirus symptoms and you're seeking medical attention, they don't want you leaving for 3 hours, going to the doctors, and coming back with those same symptoms. And keeping in mind that these days the doctors can't give you a test and say you're clear, go back to work. It's not that simple these days. So that's the reasoning for it. Why is childcare an exception? Because with childcare, you're not necessarily worried about them having the coronavirus. You're trying to allow them to take care of their children whose schools are closed and whose daycare is closed. So it makes a little more sense that at some point during the day, you may need to go and relieve your spouse who's looking after the children and needs to get back to work too. And you don't have that same concern that you're going to come back and spread the coronavirus. That's what the Department of Labor says. Now, the state of New York says, no, Department of Labor, you're dead wrong. Number one, there's nothing anywhere that indicates that the employer must agree for intermittent leave. And on the other hand, the FMLA proper says you can take intermittent leave. And furthermore, there's nothing about this working on site thing. So that's one area that the state of New York has taken issue with the regulations. And like I said before, there is nothing in the act to indicate that this is okay. And there is some indication, at least through the FMLA, that you should be able to take intermittent leave. I don't know where this all comes out. Agencies are usually allowed a certain amount of discretion by the courts in interpreting statutes that over which they have administrative authority, and that is the case here. The Department of Labor clearly has administrative authority with regard to the FFCRA as well as the FMLA. But it's not unlimited, and many courts have overturned agency regulations that relate to statutes over which they have authority. So I don't know where this all comes out, but this is one I'm going to be looking at very carefully. The Department of Labor's literature does say, you can only take intermittent leave if the employer agrees, but it goes on to say at some length, we encourage employers to work with employees and to be, understanding of their needs and so forth and so on. I would be very careful about denying intermittent leave. I wouldn't necessarily deny intermittent leave just because I can. That's not a very good reason. And I think it's entirely possible that one way or another this is going to change. So that's something I would pay careful attention to if I were you, intermittent leave under the FFCRA. This is another area of contention. What kind of documentation and information does the employee requesting leave have to provide? And the regulations got quite specific on this. The statute was not. So we have kind of a similar situation here. And I'm paraphrasing the next bullet points here. I'm paraphrasing. So if you really need to get in the weeds on, what is the qualifying reason for leave, that the employee actually provides as much information as necessary, you're going to need to drill down into the regulations. And, obviously it would help to consult a competent employment counsel. But these are the reasons. The expected dates of leave, the qualifying reason for the leave, the healthcare provider or government entity issuing a quarantine or isolation order if that's an issue. And then for child care, the name of the child care facility or school which is closed or unavailable, and a statement that no one is available to care for a child or the child. So this was also challenged by the state of New York. The state's arguing that that's a lot more than is authorized by the statute, and there is no basis for the Department of Labor to come up with regulations that are so detailed, and in effect, they are making it more difficult for an employee to take advantage of the benefits of the FFCRA, and New York feels like it's going to be harmed because more people are going to get sick, and they're going to have to deal with them. So this also is an important point of the New York lawsuit. Some of the other provisions of the FFCRA, there was an anti-retaliation provision. I'm not going to talk a whole lot about it because it's very similar to the anti-retaliation provisions in Title VII, the FMLA, and a lot of the other employment statutes. You cannot take adverse action against an employee for, number one, availing himself or herself of the benefits of the FFCRA or complaining that you're not following the FFCRA. And when I say adverse action, those of you who are really geeky like I am, it's not quote-unquote adverse action in the Title VII sense. In other words, it doesn't need to relate to the terms of the conditions of employment, such as pay or benefit. It could be anything that would cause a reasonable employee to hesitate to avail himself or herself of the benefits of the Act or to complain about a failure to comply with the Act. So things like reassigning an employee to less desirable duties, that could be retaliation. Where it might not be discrimination under Title VII or a discrimination statute, it would be enough for retaliation. Retaliation claims, most of us believe, are very dangerous. They often succeed even when the underlying discrimination or other claim does not. And it's a lot of managers are just, they seem to be prone to retaliation because they get angry when an employee complains about them or taking leave and they don't know how to deal with it. So this is the anti-retaliation provision here is not different really from the ones you're used to dealing with, but it is very important. Some of these other ones, again, don't directly affect the workplace, but they're in the Act: free coronavirus testing, expanded unemployment benefits and funding, and then expanded food programs, also important parts of the Act. So that's the FFCRA. We're going to move on to the COMPS order. So the COMPS order is what we, for many years, have been calling the minimum wage orders. And the minimum wage orders for many years have been issued. A new one has been issued every year, and every year they have a new number. The first one, I guess, many years ago was number 1. The next year was minimum wage order number 2, and I think we were up to minimum wage order 35 before the COMPS order was enacted this year. But the term minimum wage order was really pretty misleading, and I'm not one for nomenclature, but I have to say I kind of agree with them on this one because that indicated that it was applicable only to minimum wage issues, and it did an awful lot more than that. It was minimum wage, it was overtime, it was a lot of working conditions. So they renamed it the Colorado Overtime Minimum Wage Pay Standards Order. That's what COMPS stands for. And the COMPS order is not just a change in name. It has a lot of very important changes from what used to be the minimum wage orders. But it deals with minimum wage and working conditions. It applies to all industries with some exceptions. And then there's that salary threshold for exemptions. I'm going to talk about all this in more detail here, but those are some of the major changes between the COMPS order and the previous minimum wage orders. The industry coverage is a big change. It applies to all industries with some exceptions. That's a big change because previous minimum wage orders only applied to 4 specific industries and not the others. And it was retail, healthcare, office support services, and something else. I forget. It doesn't matter now because now it applies to all industries with some exceptions. And the list of exceptions is too long for me to go through here. but just a couple of examples. There are industry exemptions, such as agriculture and the ski industry, and then there are position exemptions. Examples would be interstate drivers and in-residence workers. So if you have any doubt, you need to go to the COMPS order and look. Like I said, it's a long list, but it's there and it's there for everybody to see. But in general, it applies to all industries, and that was a huge change. There was a lot of argument over that, but that's what it says now. There are exemptions which are fairly similar to some of the federal exemptions for minimum wage and overtime, and this is where you get into employees that are compensated by salary as opposed to hourly workers. Under the federal law for many years, you've had two primary tests. You've had a duties test, which, like the name implies, talks about what are these employees doing and the certain criteria there. And then there is a salary threshold. So what the federal law for many years has said is that for someone to be exempt from the minimum wage and overtime requirements, such that you can pay them on a salary, you have to pass a duties test, and you have to pass a salary threshold. You have to satisfy the salary threshold. Colorado has never had a salary threshold up to this point. Now it does. And furthermore, this salary threshold is going to exceed the federal threshold in the very near future. And here's what it's going to do. July 1st, 2020, it's going to go up to $35,568, which is the federal threshold. But on January 1st, 2021, it goes up to $40,500, which, unless they increase the federal threshold, will be above the federal threshold. And then it's going to increase by $3,000 per year until reaching $55,000 in 2026. Thereafter, it will be adjusted annually by the CPI. So starting January 1st of 2021, unless the federal threshold is amended, and I don't think it will be, Colorado is going to have a higher salary threshold for exempt employees in Colorado than the federal threshold. So those of you who are dealing with employees in numerous states, you're really going to have to pay attention to that. Colorado is not the only state that's doing this. So unfortunately, we're going to have this thing that we all hate, this quote unquote patchwork of employment laws. And you're really going to have to be on the ball on this. You're going to have to know that that starting January 1st, 2021, the salary threshold in Colorado is $40,500. If you're a multi-state employer, you may have to know that certain other states have different thresholds. But unlike previously, you're not going to be able to simply comply with the federal threshold and be confident that you're doing what you need to do for your exemption. Now, there's still a duties test here. As I said before, in order to be exempt from minimum wage and overtime requirements, you have to pass both of these tests. So the salary threshold, you have to pay them at least that amount on a salary basis. But the duties test still exists. Now, this hasn't really changed, and these are very similar to the federal threshold. So, for instance, an executive is kind of what it sounds like. It's someone that manages on a regular basis 2 or more other employees, that makes decisions of significance for the employer. And there's a laundry list of requirements there, and you have to be careful about that. But this hasn't really changed that much. If you're familiar with that from federal law or previous wage orders, it really hasn't changed. But you still have to comply with it. So the salary threshold has changed or will be changing, and but the duties test will not be changing very much, but you still have to comply with it. So overtime pay, this has not changed from past wage orders, but I mention it now because it applies to all industries unless exempt. So I think it's easy. People are going to get tripped up on this because if they're not paying close attention, they may not realize that they're now covered, or they may forget about it. And this is a little different from federal law. If you work more than 40 hours per work week, you're going to be entitled to overtime at time and a half. But if you're working 12 hours per work day, or 12-hour consecutive hours with regard to the start or end time of the work day, you're also going to be entitled to overtime for that day. So that is different from federal law, and you need to pay close attention because it's now going to apply to most of you, and it's an easy thing to forget. Rest periods are required by the comp order. This has changed from previous the minimum wage orders in some respects, but once again, it's now going to apply to all industries. So if you were not previously subject to this, please make sure you take a close look and find out if you are, and if so, be careful to comply with it. But every employer must authorize and permit and accommodate a 10-minute rest period for each 4 hours of work or major infractions thereof. There's nothing, that's the same as the wage orders, but this is new. This is a table that they provided in the COMPS order. So if you're working 2 or fewer hours, you don't need to provide the employee with any rest periods over 2 and up to 6, 1 hour, and so forth and so on. Fairly, intuitive, fairly self-evident, but they've added a lot more detail here, so a good thing to pay attention to. There are some exceptions. A written agreement up to 1 year where the employee and the employer agree to have 2 5-minute breaks instead of 1 10-minute break. I don't know how important that is to people. Maybe it is. And then there are some exceptions for collective bargaining agreements. So the rest periods have changed a bit. The one thing that hasn't changed very much is you're also entitled to a 30-minute unpaid meal period. That's the same as previous orders, but again, those of you who were not covered before may be covered now. An unpaid 30-minute lunch period, and if it's not practical to provide that because of business necessity, that's okay, but you've got to let the employee work and eat while he or she is working, and you've got to compensate the employee for what they call a working lunch. That's the same as past wage orders, but again, it will apply to some of you when it didn't before, so another good thing to pay attention to. We're now going to talk about the Equal Pay for Equal Work Act. This was a law that was passed in the last legislative session, and it amended the existing Pay Equity Act, which has existed in Colorado for many years, but it expanded it significantly. It applies to all employees in Colorado, and it takes effect January, I think actually it's supposed to be January 1st, sorry about that, 2021. I'll note in passing that there is a federal Equal Pay Act, which does some of the same things. And the main purpose is to eliminate and make unlawful disparities in pay based on gender, which has been a concern for many, many years, decades. The Equal Pay Act has been around, I don't know how many decades, a very long time. But Colorado, in the last legislative session, decided to take it to the next level, to take it to another level, and to make it much more strict, and that's what it does. So starting January 1st, 2021, this is what the law is going to require. Wage differentials based on sex are prohibited. That's not really, that's not a new concept. But what they did do is they eliminated, or they significantly eliminated the times when there can be a differential based on gender. So it's prohibited unless the employer proves the differential is a result of, I'll get to in a minute, but I want to pause here for a minute, unless the employer proves. That is something that is very significant. That makes it much more difficult on the employer to fall under one of the exceptions that I'm about to get to. Generally speaking, when someone sues someone else, that someone, the plaintiff, has to prove his or her case. That means they have the burden of proof. And that does give them a disadvantage. The defendant doesn't have to prove anything in most cases. It's the plaintiff that has to prove. But there are some situations where the defendant does have to prove something, and this is one of them. So if there is a wage differential based on sex, it's going to be prohibited unless the employer proves that the differential is the result of one of these things: a seniority system, a merit system, a system that measures earnings by quality or quantity of production, a geographic area reason, education or training or travel. Well, let's think about this a little more. Why would this make a difference? Well, I mean, it may very well be that that there's a lot of men in the workforce in a particular company that are making quite a bit more than the women. Is that necessarily wrong? Well, no, there may be a reasonable explanation for it. What would that be? Well, it might be a seniority system. It might be that the men have been there a lot longer. And there might even be a union contract there that is impacted by this that says you've got to pay people more based on seniority. So that's one area that the legislature says, okay, I mean, that may be a legitimate, reasonable explanation for a pay disparity. And if the employer can prove it, again, the employer has to prove it, then it's probably going to be permissible. A merit system, a geographic area issue. That's another one that, okay, the men are making a lot more money, but the men are living in Denver, and the female workers are predominantly somewhere else where there's a lower, wage or something like that, education or training. I won't go through all of them, but all of these could be legitimate, non-discriminatory reasons for a disparity. And if the employer can prove them, then the employer is not going to be in violation of this law. Now, one thing that you don't see here is a catch-all. Any other legitimate, non-discriminatory reason or non-gender-based reason. The federal law has that. And that's something that's been used very effectively by employers in defending against these claims. And they've pointed to all kinds of different reasons, some of them similar to some of these, but not necessarily. And the Colorado legislature felt very strongly that needed to go, and that was a topic of a lot of conversation and argument because employers wanted that. And the argument was, look, we can't foresee every single factor that might be a legitimate reason for a pay disparity between male and female workers, and if we can prove that it's legitimate and non-discriminatory, even if it's not on this specific list, we should be able to defend ourselves on that basis, whatever it is. And the Democrats in the legislature that were pushing this bill simply did not allow that. And so we have no catch-all, and that is a big change. So these are the reasons that specified in the statute that would allow an employer to avoid liability under this statute, even if there is a disparity based on gender. But in addition, those reasons must be reasonable, and wage history was not relied upon to justify wage differentials. Now, this is another important point. Wage history is something that this legislature did not like at all. And they're not the only ones. A lot of lawyers and writers and scholars don't like it either. Why is that? Well, there has been a disparity based on gender in this workforce for many years, many decades. No doubt about it. And we've been in the government, and many people have been trying to stamp that out for a long time. But one of the things that a lot of people believe that has perpetuated this disparity is the use of wage history in recruiting and pay decisions. And the idea is that since we, acknowledging that there has been a disparity, if the recruiter says to a candidate, well, what did you make in your last position? And the answer is X, then in order to hire that person, if they want that person, the recruiter or the company is more likely to pay X or something close to X to get that employee to join them. On the other hand, if it is Y and Y is less than X, then they're probably going to pay Y or something close to Y because, as rational actors in the economy, they don't want to pay more than they have to. The problem is that women historically have been paid less. So if you're able to ask about pay history, it is likely to perpetuate this disparity because even if you're not intentionally discriminating, you're just more likely to pay less if you can. And more often than not, the women are the ones that have received less. So that's why you see so much emphasis on wage history, which brings us to the second big issue under the Equal Pay for Equal Work Act. It prohibits employers from inquiring about compensation history of candidates, as I just explained. That is now specifically illegal. It has not been illegal previously. It has been introduced in previous legislatures, but it's never passed. It's not illegal federally. So that is a big change. It doesn't prohibit the candidates from disclosing, and I can see why some candidates might want to do that. They kind of cuts both ways. Well, you know, I'm not going to come work for you for that because I made X at my last job. And that's a pretty tricky area for employers. There's nothing that says that the employers can't listen if the candidates say that. I'm not sure it's a good idea, to be honest with you. I think all of you who are recruiting and competing for candidates need to get away from inquiring about compensation history. I've had conversations with many of you offline on this. It's something I'm very interested in, but I've talked to enough of you. I think there are other ways to do this, and I think we need to get used to using those other ways to try and figure out, you know, who's a good candidate and how much we need to pay them to get them to agree to work for us and to have a fair and appropriate wage. This brings us to the third major area here under the Equal Pay for Equal Work Act, and that is that employers shall make reasonable efforts to announce, post, or make known all opportunities for promotion to all current employees on the same date before a decision is made. So the idea here being that discrimination and other inappropriate activity is going to be a lot less likely, including disparities in pay based on gender, if employers are required to be transparent and to open up opportunities for promotion to everybody. Now, this is, there was a lot of controversy about this. A lot of employers and business organizations and employer advocates group felt like this is going to be very burdensome on employers, and I think it may very well be. What does opportunities for promotion mean? The statute doesn't define it. It's not clear. The courts haven't ruled on it yet. This law hasn't even gone into effect yet, so there's going to be some lack of clarity there. It's, you know, probably pretty much what it sounds like, but there's definitely gray area. If there's, I mean, certainly if an employee, a manager leaves the company and that position is open, and you're going to promote somebody from within, that's an opportunity for promotion. But what if you create a new position? Is that an opportunity for promotion? What if you're simply raising a salary or a pay grade? Is that an opportunity for promotion? There's going to be some controversy there. I don't have the answer to those questions. And the courts are going to probably figure them out as time goes on, or at least some of them. And it could be that the legislature amends the statute to make that more clear, but there is gray area here for now. So you've got to make reasonable efforts to announce, post, or make known. How do you do that? It's not clear either. But I think practically we'll figure out how to do that, especially in this day and age. I think that a blast email to the workforce would do it. I think posting on an intranet site would do it. I'm sure there are other ways to do it. But you've got to do that before you make the decision. What does this mean? Well, promoting from within is going to be much more difficult. And, you know, the situation that a lot of us have been in where you've got, you know, Joe Blow is retiring, so we're going to promote, you know, the other employee that's reported to him or her for many years and is a real go-getter, and we have a lot of confidence. We're just going to put him or her right in that position. Those days are over. You're going to have to, you can put that person in that position, but you're going to have to post first, which means what? Well, you may very well have a bunch of other people applying. You may have to sort through that. Some of those people may be unqualified. Some of them may be the wrong fit for various other reasons. And you're going to have to start thinking about discrimination. How do we say no to this person who's a protected class and say yes to this person that is not a protected class, which quite frankly was probably part of the reason for this statute. But it's going to make things more difficult when you're trying to promote from within, and even when you're not promoting from within. I think it's going to make things more difficult. But that's where we are. Let's see. Did I do this? See. Okay, so the announcement must include the compensation or range of compensation and a general description of benefits and all other compensation. So now you're being required to disclose how much you're paying. That's something that a lot of employers traditionally have been reluctant to disclose. It's competitive. You may not want your competitors to know because they're going to be able to pay more and get some of your best people or compete more effectively. So again, there are costs and benefits, but this is what the law says. Enforcement is kind of interesting. For the pay discrimination and the wage history provisions, there is a private cause of action. Retaliation is also actionable. There's economic damages, liquidated damages, equitable relief, and attorney's fees. Those are the normal, very similar to a lot of other employment discrimination statutes. If the employer proves, again, the employer proves that it acted in good faith, the court, I think actually, I'm sorry, this is a mistake, it may not award liquidated damages. If the employer proves good faith, the court may not award liquidated damages. What are liquidated damages? They're 2 times the economic damages. So if the economic damages are $100,000, then the liquidated damages would be another $100,000 on top of that. For the transparency provisions, this is the requirement that the employer post promotion opportunities. There is no private cause of action. There's enforcement by the Department of Labor with fine schedule, but there's no private cause of action. This was a great topic of conversation. The business groups and employer groups really don't like private causes of action. The reasons are probably obvious. And so they were able to make some headway here. If you forget to post up promotion opportunities, you're not going to get sued by an employee, at least not yet. That could, who knows if they'll amend the statute in the future, but there could be enforcement by the Department of Labor. And there's me. So we have about 5 minutes left here for questions and answers.
Thank you, Colin. Definitely helpful, I think, in just sharing what we need to be aware of and what we're thinking. We do have a couple of questions. I'm seeing if they can be general enough, so we'll see one question that we had, and since we're in the Equal Pay for Equal Work Act, we'll start there. So if we have a career path that says that this is what it takes to move from like a Tech 1 position into a Tech 2 or the next level up, would you consider that reasonable for making known an opportunity for promotion? And I don't know if that's
I would.
enough.
I think. Yeah, no, I do. I think that's very appropriate, and I think it's going to help you to have those kind of criteria, because you are probably going to get people applying that are not going to be qualified. And if you tell them they're not qualified, they're going to want to know why, or their lawyer may want to know why. I would caution you to think real long and hard about those kind of criteria, because once you have them, you're going to have to live with them. And you know what happens if you have some real go-getter that doesn't have all those qualifications, but you think he or she's going to be a great fit for this position that just vacated. If you deviate from it, that could cause problems as well. But I do think that's an appropriate thing to have.
Right. And that's one of the things I think, Colin, that we're also seeing is even first just making sure right now, prior to January 1, you kind of need to know where you are, and you need to make sure you really understand what your process is, right? In order to make sure you're validating it accurately. We do have a couple of more questions. Let's see if we can get to them really quickly before the end of the hour. What if, this is also equal pay for equal work related. So what if you are promoting a person from a department and not backfilling that position? Do you see a need to have to do any kind of compliance things in this space?
The law does not require, does not have any requirements regarding positions that are not, that are eliminated or that are not filled. It is really focused on opportunities for promotion. So I think the key is to looking at how you're handling the promotion and not necessarily what happens to the position that's not being filled.
Okay. And then this one is also more the FFCRA related. It may not be directly related to that, but just curious on your thoughts. The question is, if an employee says they are sick but does not think it's coronavirus, can you ask about their symptoms, or what is the requirements of the employer at that point, right?
Yeah, okay, this is interesting. This gets to a slightly different topic, but it just so happens that I'm preparing another webinar on this topic, and that is what coming back to work after the stay-at-home orders and after the coronavirus. And there's a lot of issues, and there's a lot of material out there now. The EEOC just issued within the last week or so some guidance on some of these issues, including the very one that you were asking about. It is permissible to ask about coronavirus symptoms. And the EEOC is really directing employers to the CDC and its website, which has a lot of information about the coronavirus and all kinds of things. But it includes what are coronavirus symptoms. So the EEOC has specifically said that an employer may ask about an employee if an employee is having coronavirus symptoms. So if the employee is coming to you and saying, hey, I feel sick, but I don't think it's coronavirus because I don't have the symptoms and I don't want to stop working, I think a very appropriate next question for the employer is, well, are you having these symptoms? Do you have shortness of breath? Do you have a loss of smell? Do you have a fever? Do you have a cough? And that's about as far as my knowledge will go, so I won't try and go further, but it is appropriate for the employer to ask those questions. And if the employee is experiencing, this wasn't the question, but I'll go a step further. If the employee is experiencing those symptoms, the employee could be sent home. You can also take the employee's temperature, and you can even test for coronavirus. The EEOC has specifically said all of that. So those are things that you can do, and it's again, as we're thinking about going back to work after stay-home orders and that kind of thing, these are the kind of things that we want to be thinking about.
Well, I appreciate you taking some time to walk through this with us today, Colin. I know there's a lot of information here. I want to thank you for your time. We appreciate you taking this time with us. I know, like you had said, you mentioned that your firm is planning to host a webinar focused on return to work strategies. And I know that you have said it's all right if we go ahead and share that information out with our attendees once you have that kind of locked down a little further, and when your target date is set. So we will be sending that out.
That would be great.
Once again, we want to encourage folks that have specific related questions to anything we talked about here to engage with legal counsel. Certainly can reach out to Colin, and then our team is planning to reach out to you to connect on some of these topics further to address some of the things that you're doing to prepare for these situations. We do appreciate your time today, and we'll be happy to provide a copy of this recording for your future reference. And Colin, we did have somebody ask if you would be able to provide your slides. I don't know if you can provide your slide deck in a PDF, and we might be able to send that out. Would that be okay?
Sure, that'd be fine.
Okay. And then I think that is all we have at this point. Anything to add? Jeannie, I don't know if you are still on mute or not, but anything to add on your end? I'll give you a moment. Colin, anything from your end?
Thank you so much for having me. It's been a pleasure.
Thank you. Jeannie, anything?
No, thank you as well, Colin. We appreciate your time.
Thank you. All of you take care and have a great rest of your day.